a tradition of this course, which is going to be like the tradition in my office, free bagel Thursdays. So if you haven't got a bagel yet, there are bagels here. Please help yourself to some tradition. We're going to start making some tradition right now. Anyhow, today I wanted to get into the subject area that I think most of you showed the most interest in when we started talking about how to design this course, and that is intellectual property. And that's that entire body of the law that deals with the protection of intellectual property rights, things that you may have heard of, like copyright, trademark, and patents. But as engineers, it's important, I think, to understand in your work the architecture, the origins, and the history of what are essentially tools or principles that you work with. In the same way, in order for you to really understand intellectual property rights, I thought I'd spend a little time today, as a matter of fact. So there's going to be no heavy lifting for anybody, no required or important reading. You just have to sit back, eat a bagel, and absorb today.
And you can get up and get another bagel.
But I wanted to talk about, so that you have an understanding of the basic architecture of intellectual property law, the origins of intellectual property law. I've had people come up to me after the class and ask me about first to file as opposed to first to invent. Well, that concept, just to use one example, has historical origins that go back to 1833. And I don't think you can understand first to file and the AIA treaty that went into effect in 2013 that changed patent law in the United States. I don't think you can understand that concept about first to file until you really understand where the concept of first to file came from. So that's one illustration of why I think it's important to spend a little time on the history and the origins of intellectual property law. You'll leave this class, I guarantee you, knowing more than most intellectual property lawyers know about the history of intellectual property law, so you'll have that going for you too. So with that, I think I've figured out that it's a left click on this computer. That's why I'm not advancing the slides. Let's talk a little bit about first of all, what intellectual property is. What is intellectual property? Intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. Can anybody else give me a common sense example of what they think intellectual property? Where does intellectual property come from? Begins with an I. Comes out of your head. Ideas. Exactly. And it's really amazing when you think about it. Intellectual property is all about something that is completely intangible. It's a concept, it's an idea, it's a creation of the human rights. But the rights are just as important as the rights that are conveyed to you when they give you a deed to a house or a title to an automobile. Those are tangible manifestations of tangible property. But the same rights attach, believe it or not, to things that we think up all on our own, which didn't exist until it was created by some inventor, some visionary, some artist, some musician, some playwright, William Shakespeare, for instance. So it's a very unique and, to me, interesting branch of the law because it involves inventions of the arts. And now that we know a little bit about what intellectual property is, what do we mean by intellectual property rights? Intellectual property rights, a like any other property right, they allow creators or owners of patents, trademarks, or copyrighted works to benefit from their own work or investment in a creation. By the way, can you think of any other reason to, or let me ask it this way. What kind of benefits can you think of are conveyed by intellectual property rights? I'll give you one example, the easy one. You get money for it. You think up of an invention and you sell it on the open market, that's a benefit. Can you think of any other benefits that are conferred by intellectual property rights? Yes, sir.
Along the same lines for exclusivity, so you can use your patent for 19 years.
And what does exclusivity do?
Well, it gives you an opportunity to exploit like the process or the invention.
Not only the opportunity, but the incentive. If you have this protected right, you have an incentive to go out there and develop it. And what does that do? I had some other hands here.
What's the incentive to?
Yeah, incentive. Who else had?
You could get published possibly, and then your ideas could be cited throughout, and then they all be looked to.
Exactly. And when you get published, and you get a bunch of money for that book or manuscript, or that treatment, if you happen to be in Hollywood, who else benefits? Everybody raise your hand, because we all benefit. Every single one of us. The chairs you're sitting in, the desks that you're sitting behind, the screen that you're looking at, the computers that you depend on, are all product of the human mind, are all products of inventors that have patents and intellectual property rights that have been protected. And not only are they, Bill Gates, all the people that invented those things, the beneficiaries of those intellectual property rights, but you are the beneficiaries. We all are the beneficiary of those intellectual property rights. Now, to give you some idea of the universality of this concept, the concept of intellectual property rights are outlined in Article 27 of the Universal Declaration of Human Rights, which provides for the right to benefit from the protection of moral and material interests resulting from authorship of scientific, literary, or artistic productions. So it is considered so important for society that the Declaration of Human Rights, which, is anybody familiar with the Declaration of Human Rights? Good, that's why we're having this talk about tradition. But it's considered such an important right that it's equated with a human right, just like the right to associate, the right to speak, the right to go and do what you please, the right to be free from discrimination. We as a society have decided that the protection of the inventions of your mind are so important that it is equivalent to any other human right. That right to protect material interests resulting from the inventiveness or the creativeness of all of us as human beings. And since you don't know what the Universal Declaration of Human Rights is, and I didn't, until I went to law school, I guess, but the Universal Declaration of Human Rights is a declaration adopted by the United Nations General Assembly on December 10th, 1948. The declaration was drafted by the UN Commission for Human Rights, which was chaired by Eleanor Roosevelt, and consisted of 18 members from countries all across the world. So this concept of universal property rights, intellectual property rights, is something that is shared by nearly all the developed countries in the world. And countries with the most desperate points of view, China, United States, Russia, England, France, all got together, 18 delegates headed by Eleanor Roosevelt, in that atmosphere that existed after World War II that led to the creation of the United Nations. They thought it was important enough that everybody sit down and decide what we as a world society, what are the rules going to be for the world. And one of the rules that they came up with when they drafted the Declaration of Human Rights is the right that involves intellectual property. The Declaration consists of 30 articles which have been elaborated in subsequent international treaties, regional human rights, human instruments, national constitutions, and other laws. The International Human Bill of Rights consists of the Universal Declaration of Human Rights, the International Covenant on Economic, Social, and Cultural Rights, and the International Covenant on Civil and Political Rights, and its two optional protocols. And in 1966, the General Assembly adopted the two detailed covenants which complete the International Bill of Human Rights. And in 1976, after the covenants had been ratified, the bill took force of international law. So Article 27, which is part of the International Declaration of Human Rights, has the force of international law. You may wonder, as inventors or students, is my intellectual property protected outside of the United States? Well, as you can see, there is a whole matrix that we're beginning to talk about here of laws that constitute the body of laws internationally that govern intellectual property rights. As a matter of fact, intellectual property rights are one of the few things that all of the countries in the world seem to be able to agree on, probably because of their commercial importance to the world. But freedom of speech doesn't mean the same thing in China as it means here. It doesn't mean the same thing in the Soviet Union or in other countries as it means here. And intellectual property rights, universal. So it's funny. I suppose it's a commentary on our society that is beyond the point of this class, but you've got to wonder why it is we all can't agree to basic human rights except for one involving the protection of commercial interests. All right, Article 27. Article 27 provides everyone has the right freely to participate in the cultural life of the community, to enjoy the arts, and share in scientific advancement and its benefits. Everyone has the right to the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which he is author. And that actually, language came from Eleanor Roosevelt. I don't know, I'm not sure it actually came from her, but the people who were advising her. And those phrases from Article 27 are the bedrock for international property rights. And they mean exactly what they say. Everyone has the right to freely participate in culture, community, the arts, and to share in scientific advancement and its benefits. So every law, every treaty, everything that's ever been written about intellectual property rights has been to serve these basic human interests. The Copyright Act in the United States Code when it comes to patents, the United States Code when it comes to trademarks, the laws in France, in Germany, in England, in Canada, in South America, all involving trademark, copyright, and patents, all were designed to follow and serve these basic concepts. Now, actually, the history of intellectual property goes back further than the International Declaration of Human Rights in 1948. As far as I can tell, the first significant recognition of intellectual property rights was contained in the Paris Convention for the Protection of Industrial Property, which was created in 1883, and the Berne Convention for the Protection of Literary and Artistic Works, which goes back to 1886. It's also known as the Berne Convention. When you talk about intellectual property rights to your lawyers in the future, when you refer to that treaty, refer to it as the Berne Convention, and they'll think you really are smart. But this is not just old law. These conventions, and a convention is essentially an international agreement or treaty. These conventions are still in force and effect today. So, taking them one at a time, the Paris Convention for the protection of industrial property was one of the first intellectual property treaties, and it established a union for the protection of industrial property. As I said, the convention is still in force as of 2014, and the substantive provisions of the convention fall into three main categories. And if you Google, Paris Convention, you can read the whole document if you want. But the most important provisions of that convention involve three main categories: national treatment, priority right, and common rules. These rules must sound sort of familiar to you if you know anything about copyright, patents, and trademarks. I think we already talked about first to file. Well, where do you think first to file came from? Any ideas? Any of those concepts from the convention sound familiar? Exactly. So the whole concept of first to file, the United States adopted first to file for the first time in 2013 under the AIA. But the whole concept of first to file goes back to March of 1883. And as I say, it's still good law today. So let's talk about national treatment, first to file, and priority rights. According to Articles 2 and 3 of the Paris Convention, juristic and natural persons who are either national or domiciled in a state party to the convention, that is, a signatory, some country that signed the treaty, shall, as regards the protection of industrial property, enjoy in all the other countries of the Union the advantages that their respective laws grant to nationals. So, because France and the United States are signatories to this convention, you, as an inventor in the United States, a country that is a signatory to this treaty, enjoy all the rights that someone in France, for instance, enjoys under their laws with respect to your intellectual property. So in other words, when an applicant files an application for a patent or trademark in a foreign country that belongs to the Union, the application receives the same treatment as if it came from a national of that foreign country. So you can go to France, you can file an application for a patent or a copyright, and you're treated the same as the citizens of that country. Their laws are available to you. And that's not true when it comes to free speech. Okay. Furthermore, if the intellectual property right is granted, that is, if the applicant becomes the owner of a patent or a registered mark, the owner benefits from the same protection and the same legal remedy against any infringement as the owner was a national owner of that right. To give you an example, if you live in France, which doesn't have punitive damages and attorney's fees available for patent infringement, and you have a patent that's infringed in the United States which does provide for punitive damages and attorney's fees, you as a French citizen enjoy all the benefits of U.S. law for your French patent. Everyone has to be treated the same who is a citizen of the states that are members of the nations that have joined this convention. Priority right, this is what we were just talking about. The convention priority right, also called Paris Convention priority right or Union priority right, was established by Article 4, and it provides that an applicant from one contracting state shall be able to use its first filing date in one of the contracting states as the effective filing date in another contracting state, provided that the applicant files a subsequent application within 6 months or 12 months for patents and utility models. We'll get into this later, but industrial designs and trademarks are treated a little bit different than patents and certain types of patents called utility patents. But in any case, the main point is that it provides that first filing will control. As I've mentioned to you, that's been one of the concerns that some of you have expressed to me. And it's something that we in the United States are finally starting to get used to with the AIA treaty, the AIA legislation that was passed by Congress. Now, the other law, besides the Paris Convention, is the Berne Convention. The Berne Convention for the Protection of Literary and Artistic Works is an international agreement governing copyright, which was first accepted in 1886. The Berne Convention requires its signatories to recognize the copyright of works of authors from other signatory countries, known as members of the Berne Union, in the same way it recognizes the copyright of its own nationals. So we have the French Convention for Industrial Rights that deals with mostly patents, and we have the Berne Convention that deals with copyrights, otherwise known as source code, movies, music. For example, French copyright law applies to anything published or performed in France, regardless of where it was originally created. In addition to establishing a system of equal treatment that internationalized copyright amongst signatories, the agreement also required member states to provide strong minimum standards for copyright law. Our copyright law in the United States Code, is based upon the concepts that we've been talking about here. That is really the beginning and the genesis of all patent, copyright, and trademark law in the United States. And copyright under the Berne Convention must be automatic. It is prohibited to require formal registration. Note, however, that when the United States joined the convention in 1988, it continued to make statutory damages and attorney's fees only available for registered works. Let me test your anecdotal copyright knowledge. When does a copyright, you can look at the screen, when does a copyright attach? When does it become a right? It's the last bullet point. Give you a hint.
Register?
As soon as you pick your pen up from the paper, whatever it is that you've written, you own a copyright. And that's under both international law and United States law. Whether it's enforceable or not, however, depends upon whether or not you register. But the owner of a copyright is determined at the moment that that person picks their pen up from the paper. That's a copyright. That's a protectable intellectual property right. In some countries, you don't have to register it. I don't think you have to register it in France. All you have to do is prove that you thought it up or used it in commerce. In the United States, in order for you to obtain attorney's fees and punitive damages, you have to register it. So you can get compensatory damages. I'll give you an example. I think I come up with a movie, or I write a book, and somebody infringes on my copyright. All I have to show in order to obtain damages for that infringement is that I used that I'm the author of that work, and that I used it in commerce before anyone else. Whether I registered it with the United States Patent and Trademark Office means nothing, unless I want to collect attorney's fees and punitive damages under the statutory framework established by Congress. And the only reason I have to do that is because the law established by Congress says you've got to register the mark before you get punitive damages or attorney's fees. But otherwise, international, essentially common law governs. And as soon as you pick that pen up from your paper, you own that copyright. Or as soon as you hit enter on that source code that you created, that's yours. You own it. My advice as a lawyer to a client would be to register it as soon as you possibly can, because if you're ever challenged one day, you're going to need to show that you were the author, that you used it in commerce. The easiest way to do that is to register it. But the fact is, as soon as you hit enter or pick your pen up from the paper, you own a copy. You're the owner and holder of the copyright. Yes, sir.
What constitutes use in commerce? I mean, with the internet today, I can post writings online for people free to view, but is that an act of commerce?
Good question. I think it is. When I try cases in front of the USPTO, one of the things that we do is we show all of the uses that our clients have put a particular trademark or copyright. One of them is Facebook. We use social media. So lots of individuals, artists, scientists, and companies have Facebook pages. And they'll often disclose through social media their inventions or, creative works. I can think of one case that we did where someone had created actually had formed a whole new board of medicine. You have internal medicine, pediatrics, cardiology. Well, they thought up on their own specialty board that was eventually approved by the American Medical Association. And they had a name for it, the American College of this new specialty. And then at the same time, somebody infringed on that. Somebody tried to use that name because, of course, they came across this doctor's work and they thought, gee, this was a really good idea. And I think I'll publish it and say it was my own. Fortunately, this person had used in commerce on social networks this name. And when we tried the case in front of the USPTO, after we tried the case in the United States District Court, that was dispositive. That is, whoever used it first owns it, usually. Because that's an indication that you're the inventor. And use in commerce is a very, very broad sort of soft term. It can be social media, it can be in a trade journal, it can be in the phone book. So how it's used is in terms of in commerce, is a very soft definition. What this person had done is they used it on their tax returns, they used it when they were doing fundraising and writing grant proposals. So, they had raised, like $30 million for research in this. And so what we did in front of the United States Patent and Trademark Office is we laid out each one of those instances where this person had used this mark in either a grant proposal, which is an example of commerce, in social media, which is another example of commerce, in scientific journals that they had created, which is another example of use in commerce. And that's how you end up proving ownership of an intellectual property right. In that particular case, it was both a trademark and a copyright, because they had to come up with an entire curriculum for training doctors in this particular new medical specialty. So not only did they come up with the name, American College of this, but they also had to, out of their own head, come up with a curriculum which is designed to advance the science and knowledge of this particular specialty, to board certify, to train and board certify, to test other doctors in this specialty to show that they're proficient in it. And that's how we prove that this trade name and this copyrighted material belong to them. Let me go back because I was about to introduce. So in addition to establishing a system of equal treatment that is internationalized copyright amongst signatories, the agreement also required member states to provide strong minimum standards. And the copyright under the Berne Convention is automatic. It's prohibited to require formal registration except when it comes to the idiosyncrasies of national law. Now, who administers all of these treaties? When you have a dispute, that somebody broke this treaty, who do you go to? Fortunately, they created an organization to deal with disputes and administering these treaties and all international conventions involving intellectual property, and it's called the World Intellectual Property Organization. Have you ever heard of the WIPO? You must have heard of the WIPO somewhere. But both the Paris Convention for the Protection of International Property and the Berne Convention are still in effect, and they are administered by the World Intellectual Property Organization. What is that? The WIPO was established in 1970. It's an international organization located in Geneva, Switzerland, in a very fancy building over there, dedicated to helping ensure that the rights of creators and owners of intellectual property are protected worldwide, and that inventors and authors are therefore recognized and rewarded for their ingenuity. This international protection acts as a spur to human creativity, pushing back the limits of science and technology and enriching the world of literature and the arts. By providing a stable environment for marketing products protected by intellectual property, it also oils the wheels or greases the skids of international trade. The WIPO works closely with its member states to ensure that intellectual property system remains a supple and adaptable tool for prosperity and well-being, crafted to help realize the full potential of created works of present and future generation. You know how I know that? Because I got that right off their website. But what it means, I'm sorry, go ahead.
Oh, I was gonna ask, the World Intellectual Property Organization, I'm wondering how big it is, like how many member states there are. Is it just like 10 or is it like 200?
No, I think that there are now, that's a darn good question.
Is it everyone or just?
It's almost everyone.
Okay.
It's almost everyone. You know, some countries have come on very recently, like the United States, you know, signs on in like 1988. China, the Soviet Union, more recent signatories. But like when you have you've heard of countries dumping goods onto other markets. Well, when you have a dispute involving these types of things, especially trade matters that implicate intellectual property rights, the forum that often they go to deal with these disputes is the WIPO. Oh, and in case you were wondering, there it is. It's so big I couldn't get the whole building in a slot. That's their headquarters in Geneva. It's a very, I've been there, it's a really cool, like, United Nations looking building, which is the way all buildings look in Switzerland anyhow. It's a big, important place when it comes to intellectual property. Now, how does the WIPO promote and protect intellectual property rights? So as part of the United Nations system of specialized agencies, it serves as a forum for its member states to establish and harmonize rules and practices for the protection of intellectual property rights. If you're the Commerce Secretary in a developing country in South America, you want to establish a system of copyright and trademark and patent law, who do you go to? WIPO. It also serves as a global registration system for trademarks, industrial designs, and appellations of origin, and a global filing system for patents. So in addition to filing patents here in the United States or in your host country, if you're marketing a product that is going to have international markets, it's a good idea to register with the WIPO. Now, these systems are under regular review by the WIPO's member states and other stakeholders to determine how they can be improved, better serve the needs of users. Many industrialized nations have intellectual property protection systems that are centuries old. Among newer or developing countries, however, many are in the process of building up their patent, trademark, and copyright legal framework and intellectual property systems. And what they do is there's one sitting there for them in Switzerland. They literally download a code, a sample code, and you know, if you're president or king of some country and you want to establish a system of intellectual property law, you can literally download it from their website and hit the ground running, as it were. With increasing globalization of trade and rapid changes in technological innovation, WIPO plays a key role in helping these systems to evolve through treaty negotiation, legal and technical assistance, and training in various forms, including in the area of enforcement. It works with its member states to make available information on intellectual property and outreach tools for a range of audiences, from grassroots level to the business sector and policymakers, to ensure its benefits are well recognized, properly understood, and accessible to everyone. Again, concepts that go back to the Berne Convention. Don't the words sound familiar? How are they funded? It's largely self-financed organization. Most of its revenues come through registration fees for its filing system, as well as through publications and arbitration and mediation services. So when you have a fight with someone that's ripping off your Louis Vuitton trademark in China, and China says, no, we invented that, maybe that you duke it out at the WIPO. It's an organization that's really dedicated to trying to move us all along in sync when it comes to the recognition of intellectual property rights. It's a global view of how intellectual property rights should be recognized, administered, and enforced. And in the world where we compete internationally, it makes more and more sense to have an organization like that. So, why should we promote intellectual property rights? First, the progress and well-being of humanity rest on its capacity to create and invent new works in the areas of technology and culture. Our progress as a society depends on creations of the human mind. So those things have to be protected, they have to be nurtured, and they have to be advanced. And that's what the law of intellectual property is intended to do. And it's intended to protect those people that are the creators from people that steal ideas. I hate to tell you, but some of the worst plagiarism and downright infringement I've ever seen has been in the groves of academia, where there is so much pressure to publish. Well, I'll tell you, in order to get a title like Professor Eager has, some people will do anything. Some people will do anything. I've seen it. And I've represented the people who've been infringed. So one of the reasons why we promote these rights are not only to advance society and technology and the arts, but also to protect those who are the innovators and creators of these important properties. Second, the legal protection of new creations encourages the commitment of additional resources for further innovation. Obviously, last class we talked about how Tesla came up with this innovative lithium-ion battery, this welding process that was truly innovative. It was actually the protection of those patent rights that advanced them to the point where they actually had created a monopoly which was no longer in their commercial's best interest. But you can bet that the investors at Tesla would never have authorized the funding necessary to develop those processes were it not for the protection that they had with international property rights, intellectual property rights. Who would invest if the person next door with more money can simply steal your processes and your designs? So protection of new creation encourages the commitment of additional resources and the advancement of the technology or science. And third, the promotion and protection of intellectual property spurs economic growth, creates new jobs and industries, and enhances the quality and enjoyment of life. What we talked about before, not only does it benefit Tesla, but it benefits everybody who wants to drive an electric car. We're all beneficiaries of these intellectual property rights. We all breathe less carbon monoxide because of these intellectual property rights. An efficient and equitable intellectual property system can also help countries realize intellectual property's potential as a catalyst for economic development and social and cultural well-being. You know, the development of the world in the 20th century has been almost all related to technology. Certainly in the 21st century, if you're going to go anywhere as a nation, a developing nation, it's going to be with technology. It's very interesting how developing countries view intellectual property rights. You know, we all complain about how the Chinese have violated our copyrights and our patents when they develop industries that seem to borrow very heavily from either Hollywood or Silicon Valley. But back in the 1800s, when this was a developing country, and instead of source code, it was the cotton gin or the automatic loom, we actually here in Massachusetts and in the United States paid people to steal patent technology from England and bring it here to the United States. So sometimes it depends on your perspective, your view of intellectual property rights and the protection of intellectual property rights. Sometimes depends on whether you're a developing country or not. But all those mills up in Lowell that created the economic development that we had here in the 19th and the early 20th century, it's all based upon patented technology from England. The cotton gin, the automatic loom, all those machines for those industries all came from England, and it was as a result of bounties or finding fees or rewards that were actually paid by Congress under our laws for people to do that. So sometimes it depends when it comes to enforcement. It depends on what side of the developing nation line you're on whether when it comes to the enforcement of intellectual property rights. And the IP system helps to strike a balance between the interests of innovators and the public interest, providing an environment in which creativity and invention can flourish for the benefit of all. Generally speaking, true, but like I said, it sometimes depends upon what side of the developing nation line you're on when it comes to whether or not your citizens are going to enjoy the benefits of these innovations and new technologies. All right. We've already talked a little bit about this, the multi-billion-dollar entertainment, publishing, and software industries, which bring pleasure to millions of people, do not exist without copyright protection. Who at Pixar is going to invest $100 million in the latest film that animation that allows parents to subrogate the raising of their children, at least for 3 hours, to Hollywood, without the protection of intellectual property rights. Without the profits and rewards provided by these exclusive rights, researchers and inventors would have little incentive to continue producing better and more efficient products, and consumers would have no means by which to confidently purchase products or services without reliable international trademark protection and enforcement mechanism to discourage counterfeiting and piracy. Can anybody think of an example of where that comes in handy? Has anybody ever got on an airplane? And airplanes are made up of two kinds of parts: new parts and replacement parts. And does it matter to you, as somebody who buys a ticket on an airplane, where those replacement parts come from? You want intellectual property rights to protect the makers of those parts, or do you want somebody in the developing world to knock off them made out of inferior materials? That's an example of how intellectual property rights benefit us all. It's not just Louis Vuitton bags and Fifth Avenue logos. It's safety products. It's the glass, the safety glass in your windshield. It's the materials in the seatbelt. It's the materials that your frames in your automobiles are made of. It's the structure of airplanes and boats and every other kind of transportation system. It's the train except for the MBTA, it's the train you ride over here every day. All made up of products protected by intellectual property rights, which we are the beneficiaries of. Determining now how to establish protections for intellectual property rights. Determining the best way to protect intellectual property is an important consideration for any business or entrepreneur. When you go out of here with your degree, if you go into business for yourself or work for a small company, you're going to be faced with this. Unique techniques, products, trademarks, brands, and packaging are all types of intellectual property. The government offers a level of protection to inventors through patents, copyrights, and trademarks, which, along with certain brands and packaging, are offered some type of legal exclusivity. So these are the types of intellectual property rights that you may be familiar with: patents, copyrights, and trademarks. I'm sure you've all heard about that stuff. Tomorrow we're going to talk about them in more detail, but we're going to start tomorrow off by talking about what constitutes intellectual property and what does not. So tonight I want you to think about these two definitions. what types of intellectual property can and cannot be protected? What can be protected? The expression in a tangible form or fixed form of an idea, but not the idea itself. Okay? So, in order for an idea to be protected, you have to express that idea in some tangible form. To be or not to be is not protected. When I write it down, there's a tangible expression of a concept. That's protected. It's not the idea, it's the tangible expression, the fixed expression of a creative idea. What can't be protected? This computer, if it doesn't behave, I'll tell you. All right, what can't be protected? A thought or an idea which has not been expressed in a fixed or tangible form. To be or not to be. How sharper than a serpent's tooth it is to have a thankless child. Worthless. But when you write it down, it's protected. Yes, sir.
If you verbally express an idea, is it considered to be tangible?
Well, we're going to talk about that. And that's what I want you to think about tonight. What else can't be protected are generally available information and methods, things that are commonly known or that have been around for so long nobody knows where they came from. Systems of measurement. You can't patent a ruler. It's not patentable. Tools used to measure, such as ruler calendars. It's been so long since I wrote this, I forgot that I used these examples. Mathematical principles and formulas. We're talking about derivatives, not patentable. Not copyrightable. Scientific discoveries. Gravity, not something that's subject to intellectual property protection. Business procedures. Phone books and directories. Compilations of data that is generally available and can be found anywhere are generally not protectable under copyrighted trademark, but we'll show you how if you hire a smart lawyer, they can sometimes be. So tonight, what I want you to think about is examples of property that are protected or are not protected. Tomorrow we'll talk about them in more detail, along with examples of intellectual property. Okay? No heavy reading. Just sit back and enjoy the bagels and finish the bagels. Okay? There are also, I think there are a few bagels. Sticky with them.